Have a quorum.
We do have a quorum being present today, and the subcommittee is now duly constituted to do business. I want to thank all the members that are here today in person with us and those that are joining us by way of Zoom. As we proceed through the meeting, if you have a question or a comment, please let us know by either contacting the staff, or if you can't do that, just kind of speak up and we'll let you get in and ask a question. So having said that, the first matter of business today is the approval of the minutes of the last meeting. Are there any additions or corrections to the minutes of our previous meeting? If not, is there a motion for approval?
So moved.
Is there a second, please? Second. Without objection, it is so ordered. Again, if you're joining us by video conference, please mute your phone at this time, and we will proceed. Please call the first regulation today.
Education and Workforce Development Cabinet, Education Professional 16 KAR 6010. This does not have additional amendments.
This regulation is being amended to update certain Praxis 2 assessments to the new version and include new assessments for other certification areas and allow for adoption of the recommended cut scores set by the Educational Testing Service.
Whomever is joining us today, would you please identify yourself at this time?
Good afternoon, Cassie Trueblood with the Education Professional Standards Board.
Thank you very much, ma'am, for being with us today. There are no amendments to this specific regulation. Are there any questions from any of the members of this subcommittee at this time? If there are no questions, again, we thank you for being with us today. Please call the next regulation.
Secretary of State 30 KAR 6011 Emergency. This does not have additional amendments.
This emergency regulation establishes procedures for the Address Confidentiality Program.
Good afternoon, Mr. Secretary, and your guests with you today. Would you both please identify yourself for the record at this time?
Hello there. This is Secretary of State Michael Adams. I've got with me my Deputy Secretary, Jennifer Scutchfield.
Again, we welcome both of you to our meeting today. There are no amendments to this specific regulation that we're hearing. Mr. Secretary, would you like to just explain this for a moment for us, if you don't mind, please?
Thank you. I know you have a packed schedule, so I'll be very brief, just 90
Please
seconds.
take your time, sir. Thank you for your time coming to be with us today.
Of course. Thank you. In 2013, the General Assembly enacted the Crime Victims Address Protection Program, which allows victims of specified offenses to shield their home addresses and register with the Secretary of State an alternative address for voting purposes. This program is open to U.S. citizen residents of Kentucky who are A, victims of domestic violence, abuse, stalking, a sex crime, or a crime against a minor victim in a criminal case that is ongoing or has resulted in a conviction, or B, individuals who have been granted by a Kentucky court an emergency protective order or domestic violence order that is currently in effect. The regulation before you implements the program's procedures. A previous version has been in effect since 2014. However, as part of our office's review of its administrative regulations, we discovered that the prior version of this rule incorrectly housed an appeal process within the State Board of Elections inconsistent with the statute. We've replaced the State Board of Elections with the Office of the Secretary of State in this regulation and made one other cosmetic change to remove duplicative language. There are no other revisions in here to the prior regulation. Thanks, and we're happy to answer any questions.
Thank you for your time and being with us today. Are there any questions from any members of the subcommittee for Secretary Adams or for Ms. Scutchfield today? There appears to be no questions, so we appreciate you coming over and being with us today in our meeting. Thank you very much again. Please call the next regulation at this time.
Department of Law, the first listed regulation has been deferred. So under Kentucky Victim and Witness Protection Program, we have 40 KAR 6010, 020, and 030, all with staff suggested amendments.
40 KAR 6010 amends to align reimbursement for meals and mileage with the rates for state employees as established by the Finance and Administration Cabinet, to revise definitions, update forms, and make other minor updates. 40 KAR 6020 amends to update the Child Sexual Abuse Medical Examination Funding Application, clarify application procedures, formalize procedures to fund regional prevention programs and statewide public education and awareness campaigns on child sexual abuse, and incorporate by reference the funding application. 40 KAR 6030 establishes requirements for the Office of Attorney General to use in the distribution of funds received to maintain programs for the prevention of human trafficking and to conduct human trafficking investigations. The staff suggested amendments for all of these regulations, amend various sections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Good afternoon to all of you this afternoon. Would you please each one identify yourselves for the record today?
Hello, my name is Heather Wagers. I'm the Executive Director of the Office of Trafficking and Abuse Prevention and Prosecution with the OAG.
Good afternoon. I'm Catherine York. I'm the Deputy Executive Director of the Office of Trafficking and Abuse Prevention and Prosecution with the Office of the Attorney General.
Good afternoon. My name is Bobby Stokes. I'm the Executive Director of the Prosecutor Advisory Council with the Office of the Attorney General.
Again, we appreciate your time in being with us today. There are staff amendments. Is there a motion for approval of the staff amendments? Second. There is a motion and a second. Without objection, it is so ordered. Would either of you like to speak on this? You may proceed.
So both the Child Sexual Abuse and Exploitation Prevention Board and the Kentucky Multidisciplinary Commission of Child Sexual Abuse are administratively assigned to the Office of Attorney General, and so these are primarily bringing them up to with the newest forms that have been incorporated and things of that nature, and so there's a lot of clarification. As for the Human Trafficking Victims Fund, that had never been established, even though the law had been in effect since 2013. So in 2020, it was administratively assigned to the Office of Attorney General, and so we wanted to go ahead and get the regulations so that we can start utilizing those funds.
Well, thank you very much for that explanation. Are there any questions from the members? Senator West, go right ahead, please, sir.
Thank you, Mr. Chairman. Does the human trafficking reg, does that tie the hands of the Attorney General in any way, as far as, does it specify these funds shall be used for this area?
No, sir. It only sets forth exactly what's in statute or what is allowed to go for, but it has an application process so that people can apply for the money, obviously, and we'd have a record trail as to explaining why they need this money and what it's going to be used for.
Okay, so if we do a line item in the budget for this, let's say, you're saying this would set up the parameters if the money would flow through the Attorney General's office, and then if a local entity wanted to apply for the funds, this kind of sets up the parameters.
Yes, sir.
For that. Okay, thank you.
Are there any other questions? It appears that there are no other questions, so again, we thank all of you for your time this afternoon and appreciate your explanation of the regulation. At this time, please call the next reg.
Thank you.
Finance and Administration Cabinet, Department of Revenue, 103 KAR 8090 and 103 KAR 16270 do not have additional amendments.
103 KR 8090 amends to add defined terms and provide additional guidance on the classification of property for public service corporations. The amended after comments version deletes definitions and a majority of the property classifications added previously and makes various changes to comply with KRS Chapter 13A. 103 KR 16270 amends to provide guidance for the computation of the receipts factor for financial institutions that are now subject to the corporation income tax. The amended after comments version adds a definition of regular place of business and makes various changes to comply with KRS Chapter 13A.
Would whomever is joining us today please identify yourself at this time for the record?
Good afternoon. I am Bethany Rice, Executive Director of the Office of Legal Services for Revenue. I have with me today my colleagues Richard Bertelson and Jennifer Stossberg, who are Assistant General Counsel, as well as Ms. Jessica Johnston, who is the Executive Director of the Office of Income Taxation.
All right. Again, welcome today for joining us. There are no amendments to these regulations that we have just had presented to us. Are there any questions from any of the members today on this specific regulation? It appears that there are no questions, so thank you again for your time today. Please call the next regulation at this time.
Boards and Commissions, Board of Pharmacy, 201 KAR 2050 and 076. 076 as a staff suggested amendment.
201 KAR 2050 amends to increase the fee for the annual renewal of a pharmacist license and the delinquent renewal penalty for a pharmacist license from $70 to $95. 201 KAR 2076 amends to allow adding a flavor to a drug without the addition being considered non-sterile compounding if the additive meets certain requirements, and implement the USP 825 for radiopharmaceutical governance in the Commonwealth. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself today for the record at this time?
Yes, this is Eden Davis, General Counsel for the Board of Pharmacy.
Thank you, Ms. Davis. Are you the only one today?
I am.
All right, thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? There has been a motion and there is a second. Without objection, it is so ordered. Are there any questions from any of the members of the subcommittee today? There appears to be no questions, so again, we thank you for your time at this point. Please call the next regulation.
Board of Licensure for Long-Term Care Administrators, 201 KAR 6020 with a staff suggested amendment.
This regulation is being amended to clarify the requirements to obtain a license and simplify the license application. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself today for the record?
Yes, sir. Good afternoon. This is Kevin Winstead. I'm with the Department of Professional Licensing. I'm now serving as the contact person for this regulation. Also attending with me are two of the members of the Board of Licensure of Long-Term Care Administrators, Kenneth Earledge, who's the chair of the board, and also Dr. Keith Knapp.
Thank you, sir, for your time today. There is a staff amendment. Is there a motion for approval of this staff amendment? Motion has been made and there is a second without objection. It is so ordered. Do we have any questions from the members of the subcommittee today on this specific regulation?
And sir, sorry to interrupt you. I think there's an agency amendment too. Is that on there as well?
The committee will stand at ease. Just a moment, please. Sir, we actually don't have that listed on our agenda, but my understanding that was filed late today sometime, so we are going to have someone speak to that agency amendment and explain what that is.
The agency amendment amends materially incorporated by reference.
So there is an agency amendment on this specific regulation. Is there any discussion on the agency amendment? Senator West.
I'm sorry, I was having discussion up here with staff. Could we hear what is in the agency amendment?
Yes.
Before we.
Could you explain, sir, what is in the agency amendment before we proceed?
Yes, sir. I'll start, and then either of the board members may be able to provide more detail as it's needed. Very simply, this agency amendment clarifies a licensure requirement regarding management experience that's required in order to obtain a license from this board. It's really to clarify where it says quality improvement, that it's quality improvement in the context of a long-term care facility. To make that clear that that's more, they're looking for quality improvement management experience in the context of the type of facility that the people that get this license will be working at. And then also, it does update one of the material, the edition date of one of the materials incorporated by reference.
Senator West, would you like to?
I'm good.
Okay. Senator Alvarado has a question, please.
Thank you very much. I'm looking at the language of it. So in section 6(1)(a), we're inserting November instead of June, correct, for the application for licensure?
Yes, sir.
But is in Form 2, the work verification form, it's not changed? So you have the work verification has to be done by June, but the application for licensure in November? Should those both be together in November?
I believe this simply changes the edition date that's listed at the bottom of the form.
Because you have two different months there, back to back, right? Form 1 will be November, Form 2 will be, I don't know if that makes a difference. That's why I'm asking.
I don't believe it'll make a difference, sir, and I'm sorry I don't have more information on that.
All right, well, staff is clarifying, I think, give me a good answer. Those are not 2 dates, so very good. That was the question I had. Thank you. Thank you, Mr. Chairman.
Yes, sir.
Committee will still be at ease just a moment. All right. Is there any more discussion or questions specifically on this agency amendment? It appears that we do not have any more discussion or questions, so now I'm going to ask, is there a motion for approval of this agency amendment? Second. There has been a motion and there is a second. Without objection, it is so ordered.
Thank you, sir.
Thank you. There being no further questions, please call the next regulation.
Board of Dentistry, 201 KAR 8520.
201 KAR 8520 amends to clarify previous language and update the fee schedule that is required by KRS 313.022. The amended after comments version amends to rephrase the reinstatement fees to more clearly comply with statutory fee requirements. The reinstatement fee amounts are unchanged.
Would you identify yourself for the record, please, whoever is joining us today?
Sure. Good afternoon. My name is Jeff Allen. I'm the Executive Director for the Board of Dentistry.
Thank you, Mr. Allen. There are no amendments. Could you just quickly give us a quick explanation of exactly what this reg is doing?
Sure. We are mostly just cleaning up some of the language. We are not creating new fees except for a charitable license fee, which is $25. We're also eliminating a fee for receiving a copy of a second copy of your license. That's also $25. So we're adding a new fee and removing a fee. The charitable license fee is the lowest fee that we found from peer states at $25. So we felt like that was a fair number to put in there. All the other fees that you see in this document are unchanged, even if we change the wording somewhat to correspond better with statute. But everything else remains unchanged, just worded in a clearer manner.
Okay, so let me make sure. There really isn't any kind of a fee increase here. Am I correct on that?
There is no fee increase other than the creation of a fee for a charitable license. But for the vast majority of licensees, nothing is changing. The license renewal fee, the license application fee, for the vast majority of our licensees, nothing is increasing in cost.
Are there any questions? We'll stand at ease just a moment. I think we do have a question.
I do have a question.
Senator Alvarado.
Thank you, Mr. Chairman. I'm looking at the reg right now. There might be a typo here, and I just wanted to make sure because it's going to lead to some confusion when we're changing fee numbers and all this. On page 1, if you're looking at section 1, subsection 6, it says the reinstatement fee for an expired dental license, or the way it's worded, reinstated on or after February 1 of the year following the expiration of the license shall be. And there's a number here with 5 digits, and it appears to be a typo. I can't tell if it's $1,141, $1,145, $1,415, because it's got 1,1415.
Yes,
So
you are correct. That is a typo.
Yeah. Do you know what the number is supposed to be? I'm sure, Mr. Chairman, you probably could correct that here if we need to.
It is 1,415.
$1,415.
Mm-hmm.
So the amount there should be $1,415.
That is correct.
Okay, so we can have the compiler change that at this point. And is everybody fine with that?
Yeah.
Okay.
It's a technical change that she can make as compiler.
So I've been informed that we really don't have to do any action on that because it's just a technical change that we can change. The compiler can change that. So thank you, Senator Alvarado, for bringing that to our attention. Are there any other questions? Thank you, sir. We appreciate your time. Please call the next regulation at this time.
It's me. Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources. 301 KAR 2015, 142, 224, 301 KAR 3012, 2730, and 110, 301 KAR 4050 and 070, and 301 KAR 6070. 301 KAR 2015 has an agency amendment.
301-2015 amends feeding of wildlife requirements for clarity. The agency amendment adds a new Section 3 to establish requirements for baiting and feeding in chronic wasting disease surveillance or management zone counties. 301-142, 224, 3012, 3027, 3030, and 3110 update language and make technical corrections. 301-4050 amends provisions for Swan Lake Unit of Boatwright Wildlife Management Area to make a technical correction. 301-4070 amends provisions pertaining to the importation, transport, possession, and sale of endangered species to clarify that a request for a KRS Chapter 13B hearing shall be in writing and submitted no later than 30 days after denial or revocation. 301-6070 amends provisions for registering boat manufacturers and dealers to make a technical correction.
Thank you very much for those explanations. Would you please identify yourself today for the record, whoever is joining us from Fish and Wildlife?
Rich Storm, Commissioner.
Stephen Fields, Staff Attorney.
Thank you, Mr. Commissioner, for being with us today. And Mr. Fields, we appreciate your time this afternoon. There is an agency amendment to one of these specific regulations. Is there any discussion on the agency amendment? There appears to be no discussion. Is there a motion for approval? Second. There has been a motion and there is a second. Without objection, it is so ordered. Are there any other questions for the folks from Fish and Wildlife today concerning the regs that have been brought before us today? Gentlemen, there appears to be no questions. Thank you, Mr. Commissioner and Mr. Fields, for your time today. I can personally say it's good to see 2 pages of regulations from Fish and Wildlife on the agenda for today. So we appreciate your time. Thank you, guys. Please call the next regulation.
Justice and Public Safety Cabinet, Department of Corrections. 501 KAR 1050 with a staff suggested amendment. 501 KAR 2020 with a staff suggested and an agency amendment. 060 with a staff suggested amendment. 110 staff suggested amendment. 120, 130, and 150 both have staff suggested amendments. 170, 190, 200, and 250 all 3 have staff suggested amendments. 501 KAR 7040, 060, 090, 100, 110, 120, and 130, 140, and 150 all 3 have staff suggested amendments. And 501 KAR 14010 also with a staff suggested amendment.
501 KAR 1050 updates parole procedures to ensure restitution is paid as required by statute. The 501 KAR Chapter 2 regs update definitions and housing procedures for jails that house state prisoners. The 501 KAR Chapter 3 regs update jail standards for full-service jails, including requirements for the physical separation of male and female prisoners, documentation of strip and body cavity searches, evidence-based programming, and providing required documents through an electronic format. The 501 KAR Chapter 6 regs update procedures and requirements for comprehensive sex offender pre-sentence evaluations and graduated sanctions for technical violations of probation. The 501 KAR Chapter 7 regs update jail standards for restricted custody centers, including requirements for the physical separation of male and female prisoners, adequate nutrition for pregnant prisoners, search documentation, evidence-based programming, and preventing intoxicants from being introduced into the facility. 501 KAR 14010 updates departmental procedures for VINE, the Psychiatric Facility Victim Notification System. The staff suggested amendments for various of these regulations, amend sections for clarity, to align provisions with current statutory requirements, and to comply with 13A drafting and formatting requirements. Additionally, the agency amendment for 501 KAR 2020 amends Section 16 to define deaf or hard of hearing inmate as an inmate who has a hearing loss that qualifies the inmate as an individual with a disability under the ADA.
All right, a lot of regulations in this group. Would you please identify yourself today for the record at this time?
My name is Amy Barker, and I'm an Assistant General Counsel representing the Department of Corrections. Also appearing by Zoom is Kirsty Willard for Chapters 2, 3, and 7, and Jennifer Bogard for Chapters 6, 190, and 200.
Thank you, Ms. Barker. We're always glad to have you joining us on our meetings. There are staff amendments to these regulations. Is there a motion for approval of the staff amendments? There is a motion and there is a second. Without objection, it is so ordered. There is also an agency amendment. Is there any discussion on the agency amendment? There appears to be no discussion on that. Is there a motion for approval of the agency amendment? There is a motion and there is a second. Without objection, it is so ordered. Do any of the members have any questions for Ms. Barker or one of her guests? Senator West has a question. Go right ahead, sir.
Thank you, Mr. Chairman. In our packet we have here, we get summaries on all the regs, and I'm specifically looking at 501 KR 1050, granting final discharge from parole. The summary heading says it amends to add additional statutory references, including KRS 439563, which prohibits final discharge if restitution has not been paid in full. Could you explain that, how that works? I think I know what it... I hope it's not doing what I think it is, but if you could explain that.
KRS 439563, Section 5, prohibits final discharge from parole unless restitution has been paid. So this was one of the sunset amendments, and we updated the authority section and added that site and made that clear that that's why this provision was in this regulation.
So I guess my question then is, and I've always had this problem with paying fines and fees, especially child support. If someone's in prison and they're a prisoner with no means, they don't have money in a savings account, how are they able to make restitution when they've been in prison for 5 years?
I don't really have an answer for that. All we did was update the requirement of the statute. We didn't make any change other than that.
So I would think that would be the ability to not make restitution would that would kick a lot of people out of the group that may be eligible for parole. Is that correct?
It's not parole eligibility. It's final discharge from parole. So if the person had finished their parole time, they don't receive a final discharge because they still owe restitution.
Oh, okay. So
this concerns. So if they have some type of violation letter, they could be potentially brought back because they never. Let me take that back because I don't want to misstate. I may be incorrect there. They just don't receive their final discharge because there's that outstanding restitution.
I misunderstood, and
certainly,
in my mind I had that these were people who are in prison, but these are actually people who have been paroled who are outside. Is that correct?
Yes.
Okay.
Yes.
Thank you.
Are there any other questions? I have one specific question I would just like to, for my own clarification, on 501-002-060. Again, the summary, it reads, amends to reflect current classification categories to remove the furlough provision, add a procedure so that inmates with 90 days or less to serve out can decide whether to be considered for parole or waive consideration to complete his or her sentence. Could you just give me a quick explanation of that? I want to make sure I'm not missing something there.
And Kirsty, would you be able to speak on that? I don't want to misstate.
Sure. So the parole board has had a number of offenders who are eligible to see the parole board, and then we go through the process of scheduling those hearings only for that offender to then get before the board and say that they want to serve out because they're close enough that they would rather defer that parole review and just serve out. And so this actually just adds a step in the process that allows that offender to do that via a form rather than go through the process of scheduling hearings and being on the parole board's calendar just to simply ask to waive that.
So that would only apply then to someone that's 90 days from release or less than 90 days?
Correct. So that means that if they're 90 days or less within the release and they decide, I don't want to be considered for parole because I'm so close to getting out, I'd rather just finish that 90 days and be completely done, they have the option to request that.
Okay, thank you very much. That was a good explanation. Are there any other questions? There appearing to be no other questions. We thank you for your time and your explanations for our questions today. Please call the next regulation at this time.
Education and Workforce Development Cabinet, Board of Education, 701 KAR 5160 with a staff amendment, and 702 KAR 7150, 704 KAR 7121.
701 KAR 5160 establishes provisions for selecting and appointing non-voting teacher and non-voting student members of the Kentucky Board of Education. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 702 KAR 7150 replaces and updates 704 KAR 7120, the former home or hospital instruction regulation. 704 KAR 7121 repeals 704 KAR 7120, home or hospital instruction, as these provisions are being repromulgated in 702 KAR 7150.
Good afternoon, gentlemen. Would you please both at this time identify yourself for the record today?
Good afternoon. Todd Allen, General Counsel for the State Board of Education.
Matt Ross, Policy Advisor in the Office of Finance and Operations at KDE.
Are your gentlemen's microphones on?
I think so.
Okay, the green light's on there. Okay, thank you. Thank you. There is a staff amendment to this set of regulations. Is there a motion for approval? There is a motion and there is a second. Without objection, it is so ordered. Are there any questions from the members today? Gentlemen, it appears there are no questions, so we thank you for being here with us today. Please call the next regulation at this time.
Thank you.
Kentucky Community and Technical College Systems, Commission on Fire Protection, Personnel Standards and Education. 739 KAR 2060 with a staff suggested amendment.
739-2060 amends to update definitions, establish 4 levels of certification: Fire and Emergency Services Instructor Levels 1 and 2, Live Fire Instructor, and Live Fire Instructor in Charge, including to remove 1, the Fire and Emergency Services Instructor Level 3. Add new language to Level 1 requirements that is mostly a restatement of existing requirements and is reorganized to include verification of the possession of the particular qualification. Add that Level 1 experience now shall meet International Fire Service Accreditation, Congress accreditation, or be subject to suitable reciprocity if from another state. Add new certifications of Live Fire Instructor and Live Fire Instructor in Charge and including the qualifications. Increase from 4 to 8 hours of methodology training for certification renewals of Level 1 and Level 2 instructors. Delete requirement for the signed fire service application. Delete references to training being eligible for firefighter recertification for instructor renewals. Delete references to Level 3 instructor. Delete references to certificate renewals of instructors originally grandfathered. Include the completion of the required form, completion of 8 hours of methodology provided by state fire rescue training, and the attendance of 20 hours of recognized fire service training for reinstatement of lapse certification, and migrate all the forms for applying for certification renewals and reinstatement to an online version and incorporate those forms by reference. The staff suggested amendment amends various sections for clarity and to comply with KRS Chapter 13A, amends Section 2 and 5 to resolve inconsistencies and clarify the grandfathering in of existing Level 3 instructors who hold that certification on or before January 1 of 2022, and amend Section 3 to reorganize the qualifications for a Level 1 instructor.
Thank you very much. Good afternoon, gentlemen. Would you please both identify yourselves for the record and make sure your microphone. You might have to pull it just a little bit closer and make sure the green light's on.
Good afternoon. John Wood, outside counsel for the Kentucky Fire Commission.
Good afternoon. Jeremy Rogers, Director of Operations for the Kentucky Fire Commission.
Thank you, Mr. Wood. Mr. Rogers, appreciate your time today being with us. There is a staff amendment. Is there a motion for approval of the staff amendment? Second. There is a motion and there is a second. Without objection, it is so ordered. Are there any questions from the members of this subcommittee for either one of our gentlemen that are with us today? It appears there are no questions, so thank you, gentlemen, for being with us. We appreciate your time today. Please call the next regulation at this time.
Education and Workforce Development Cabinet, Department of Workforce Investment, Office of Employment and Training. 787 KAR 2040. This does not have additional amendments.
787-2040 amends requirements for local workforce development areas to make technical corrections, delete specific policy numbers, and remove material incorporated by reference.
Whomever is joining us today, would you please identify yourself for the record at this time?
Good afternoon. This is Honor Barker, Deputy Commissioner for the Department of Workforce Investment.
And Scotty McFarland, attorney with the Education Workforce Development Cabinet, Department of Workforce Investment.
Thank you, Ms. Barker, Mr. McFarland, for your time today. We appreciate that very much. There are no amendments for this specific regulation. Are there any questions from the members of the subcommittee today? It appears that there are no questions, so we thank you for taking time to be with us. If no questions, please call the next regulation at this time.
Thank you.
Labor Cabinet, Department of Workers' Claims, 803 KAR 25-190. There is an agency amendment and a staff amendment.
803 KAR 25-190 amends to add requirements for the Utilization Review and Medical Bill Audit Program, including requirements for approval, elements of the audit, personnel qualifications, appeals of utilization review decisions, and the medical director position. Amends to add definitions and update and clarify language. The amended after comments version changed the date relating to implementation of requirements from January 1st, 2022 to June 1st, 2022, clarified communication requirements and requirements relating to the position of medical director, added a hospital representative to the Workers' Compensation Medical Advisory Committee, clarified timelines, and deleted the provision allowing any party to appeal a medical audit reconsideration decision. The staff suggested amendment amends various sections to comply with KRS 13A. The agency amendment amends to change the following criteria that would subject related medical services to a utilization review. Total cumulative medical costs are increased from costs that exceed $1,000 to costs that exceed $3,000, and total cumulative lost work days are increased from 15 days to 30 days. Also amends to establish additional medical director requirements, including the duration of a medical director's term, appointment, and removal, and authorization for the medical director to seek assistance from physicians with the appropriate certification or specialty if the treatment is outside of the medical director's certification or specialty. It also amends to return the appeal period for utilization review decisions to 30 days instead of 45 days, to reduce the appeal fee from $400 to $200, to increase the amount of time to pay the appeal fee from 15 to 21 calendar days, to require the medical director to conduct the appeal in keeping with the treatment guidelines and pharmaceutical formulary created or adopted by the commissioner, to require the medical director to consider the opinion of the medical provider whose recommended treatment, or prescribed medication is being denied. Amends also to increase the amount of time to file the medical dispute form from 14 to 30 calendar days and make clarifications and comply with KRS Chapter 13A.
Thank you very much. Would you please identify yourself today for the record, whomever is joining us today?
Good afternoon, Mr. Chairman. It's Robert Walker, Commissioner of the Department of Workers' Claims.
Good afternoon, Chairman. Sam Flynn, General Counsel with the Labor Cabinet.
Good afternoon. This is Dale Hamlin. I'm the Assistant General Counsel for the Department of Workers' Claims.
Mr. Flynn, Mr. Hamlin, Mr. Walker, we appreciate your time being with us today. We are going to proceed in this manner. I'm going to go ahead and allow you to present what you have to say for us first, and we do have an individual that is going to also speak against this specific regulation. But before I do that, there is a staff amendment. Is there a motion for the approval of the staff amendment? There is a motion and a second. Without objection, it is so ordered. So whomever would like to just give us a quick rundown of just a few minutes of what your regulation here is attempting to do, please proceed.
Thank you, Mr. Chairman. This is Robert Walker again, Commissioner of the Department of Workers' Claims. I know we had a chance a couple months ago, to discuss this regulation with you, so I'll be brief this time. This allows substitutes the medical director for a reconsideration process in the utilization review process in front of the Department of Workers' Claims. What this does, it will essentially shorten the time that an injured employee gets a decision on whether or not their treatment is reasonable and necessary. I continue to believe that this regulation will speed the delivery of medical benefits to injured workers in Kentucky. Specifically, it'll shorten the time frame down from 1 week to 4 weeks. It also provide a medical advisor in the Department of Workers' Claims. I do not, at this point, have any medical expertise here at the Department of Workers' Claims, so it would be nice to have a physician in the department so that we could discuss with them pharmacy formularies, physician fee schedules, and such. The regulation also will establish an advisory committee that will be chaired by the medical director and will have a representative from each sub-practice in the medical field, and also representatives from self-insureds, labor, employees, and employers. This is something that the department has been working on for over a year. We've given consideration to all stakeholders. We've talked with plaintiffs' lawyers. We've talked with defense counsel. We've talked with insurance providers. We've listened to their suggestions, and we've made several revisions. And I think this is a regulation that can be fair to all stakeholders and speed the delivery of medical benefits to injured workers in Kentucky.
Would either of the other gentlemen like to say anything?
I have nothing to add to that. Thank you.
I don't as well.
All right. Thank you. Thank you very much. We do have some questions on this specific regulation. As was stated, this has been before us before. Quite a bit of conversation and has been mentioned about this regulation with specific meetings. And so I'm going to start with Senator West. I think he has some questions or a question or two he'd like to ask. Senator West, proceed.
Thank you, Mr. Chairman. Mr. Chairman, I would request that we hear the gentleman signed up to speak against first, and then allow for questions. That's my request. You're the chairman. But.
That will be perfectly fine with me. Mr. O'Daniel, are you joining us online today?
Yes, Mr. Chairman. I'm here.
Would you please, sir, before you proceed, identify yourself and for the record, and then you have 5 minutes.
Yes, I'm Ed O'Daniel. I represent American Property Casualty Insurance Association. We had made some comments about the regulation, submitted them to the committee. I think you have those in your folders today. Just briefly, I wanted to present to the committee some statutory conflicts in the regulation that I think make the new regulation statutorily deficient. First, the new regulation has a fee of $200 assessed for appealing a UR decision. And this fee is in direct conflict with KRS 342.035 sub 5, which states that the cost of implementing and carrying out the requirements of UR shall be paid from special fund assessments, which are collected from employers. And there's adequate funding in the budget to continue to cover the cost of UR as it's been done in the past. The second deficiency, the General Assembly in 2018 created KRS 342.035 sub 8, directing the commissioner to adopt medical treatment guidelines and a pharmaceutical formulary for treating injuries and occupational diseases. The appeals process in the new regulation allows the medical director to authorize treatment or medications that may violate the medical necessity standard of the guidelines. And this would all come at the additional cost to Kentucky employers. Third, the statute authorizing the administrative regs to adopt regs on utilization review, 342.035 sub 5C, that statute doesn't authorize the creation of a medical director position. Instead, that regulation directs the commissioner to report to the interim committee on economic development and workforce development any recommendations that are needed for compliance. And so if a medical director is needed by statute, it should be reported to the General Assembly. And this is a policy spot that should be done by statute, not by regulation. And the fourth item, and I hadn't mentioned this before, there's an invalid penalty that's been put in the new regulation. By statute, a fine of $100 to $1,000 is imposed for violations of the UR reg. This new reg imposes a penalty requiring the payment of costs and attorney's fees for failure to follow the UR procedure. And there's no statutory authority for that. So just to conclude, Mr. Chairman, the current UR reg has been in use successfully since 1995. It's worked well. There hasn't been shown any need for changing it. So this new reg is a fix for a problem that doesn't exist. It adds necessary costs, and it's going to be disruptive. It's going to be expensive to employers if this reg is allowed to be implemented. Thank you, Mr. Chairman.
Thank you, Mr. O'Daniel, for your testimony today. In all fairness, I do want to allow Mr. Walker, if he would like to respond to that for just a couple of minutes, if you'd like to, sir, or any of the ones that were with you. Would you have any comments as to responding to Mr. O'Daniel's comments?
Sure. Just briefly. First, regarding the fee imposed, this is an appeal of an UR. So the statute that Mr. O'Daniel was talking about was actually the UR process itself. This has been described and will be described in the reg as an appeal of a UR. He also, Mr. O'Daniel, discussed some of the authority from the Enabling Statute. As we said in our necessity, function, and conformity section, this basically derives from the authority given by the legislature to the commissioner to speed the delivery of medical benefits to injured workers. And this is exactly what the medical director position will do. It will get a decision quicker to the injured worker. And we all know that if our main goal is to get injured workers back to work, if they get medical treatment, get their decisions quicker, they'll get back to work quicker. Everybody wins at that point: employers, insurance companies, and employees.
And Commissioner, if I may, just on that note, this is Sam Flynn, General Counsel for the Labor Cabinet.
Yes, sir, Mr. Flynn, go right ahead.
The statute that the Commissioner references, I believe, is 342-260, and that actually provides the authority to, as the Commissioner mentioned, hasten the speed at which the UR process is administered. And the statute that Mr. O'Daniel mentioned, 342-035-5, does not actually prohibit the creation of a medical director for that purpose.
All right, thank you, sir. We do have some questions at this time, and Senator West, I'm going to begin with you, and if there's any other questions, just please let me know, or any of the individuals that's online with us today, just let us know, and we will get you in the order of questions. Senator West, you are first.
Thank you, Mr. Chairman. Got a question. This regulation, obviously we've seen it before. I think it's been deferred 3 times now, which is fairly unusual. And then we had, at the beginning, had several concerns and red flags. And the more I heard about it, the more I wanted to know. And so we had testimony on this. And then I went so far as to set up a meeting with Senate leadership on this issue. I think everyone on the screen there was in that meeting with leadership. Since our meeting with Senate leadership, and one of the senators in there was a practitioner in this area, has there been any changes to the reg that's before us since that meeting?
No, Senator.
Okay.
No, Senator.
Okay. That's all the questions I have this time.
Any other questions? Senator Alvarado, go right ahead, sir.
Thank you, Mr. Chairman. And again, I'm going to reiterate my comments I made earlier when we had the discussion on this regulation. This effectively creates a medical review panel of one for an issue regarding this issue. And great, I don't necessarily oppose the policy of medical review panels. But your arguments that you give as to why we need to do this are the same arguments I gave for medical review panels in the past. And I think we've discussed it before at our last meeting, if there's been no changes to it, that Supreme Court's already issued a ruling on this, that if anything delays time to the courts potentially, doesn't matter how good or wise the policy is, because I've argued for medical review panels to expedite these things, to get people that have been wrong within the medical system quicker responses instead of waiting 6 to 8 to 10 years to get a chance to go before the courts to get any kind of rectification for wrongs that have been done to them within the medical system. Review panels can get them done much more quickly, as has been proven in many other states. That all was thrown out the window. Nobody cared. It was all about constitutional authority and delay of time to go into the courts. I think something like this is going to require statutory authority. And I don't necessarily disagree with the policy. I'm not saying I'm against the idea of what you're trying to get accomplished. I just don't think that you have the authority to do it. It's going to require the legislature to act on it. And for us to act on it, it's going to require a constitutional amendment to give us the authority to do this. I've filed it yearly. I'll continue to file it every year that I'm here to give ourselves that authority. But our Supreme Court has said we don't have the authority to do that. And I don't know that we can do it this way by just bypassing it through regulations. So I think it's going to require changes for us to get something like this accomplished. I don't know that this is going to be legal to do. And I know your arguments will say that, yes, we are. I'm going to say, no, you're not, based on my experience with the time that I've spent here in the legislature. So, Mr. Chairman, I would just argue that this is a medical review panel of one regarding this issue. Don't disagree with the idea, the policy behind it. I just don't think we have the authority, and we've got to make changes. And if members are willing, like I said, I'll be filing that bill again this upcoming year for us to change our Constitution to give the legislature the authority to act on issues like this, which are going to benefit people that have been injured. That's all I have to say. Thank you, Mr. Chairman.
Thank you, Senator. We have a question from Senator Yates is joining us today by video. Senator Yates, you may proceed, please.
Thank you, Mr. Chair. I don't want to get off topic. I know that Attorney Flynn had addressed it at last time we discussed a little bit about the review panel, and just reading the case law on it, I think that the major distinguishing factor is just access to courts, and that this actually doesn't hinder access to court. But as I'm reading through it over and over again, it does look like this is a benefit for employers and for employees, is that it gets our constituents, all of them, it gets them healthy and back to work sooner and faster. In my law office, just the other day, one of my paralegals decided to hang a plant in the windowsill. She stepped up on it. It's only about a foot off the ground, and she fell backwards and she bruised her tailbone, was hurt. She went in there, wanted to get treatment. I got a call from the workers' comp saying they were going to deny the claim because they felt like that it was outside of her job duties. And, I had explained to them that I wasn't the one going to be hanging the plants of water. And they, I think when the employer stepped in, they decided to take it. I don't know how often that happens, that there's that denial, it goes through, and how long would she have been out without getting treatment, without getting care, being back in the office? And so I know that it may be fault by some of the insurance companies at this point, because it may get into some of the profits there for the people who otherwise just wouldn't seek treatment. But for our Kentucky families that we all represent, for the individual employers who are out there who want their employees healthy and back to work, it seemed like a win-win. As far as the constitutional issues, though, I mean, I've learned that as an attorney, I try to look to the attorneys who we hire or specialize in certain areas. So I would defer to your expertise, but simply my review of it, looking at it, it does not look like this in any way hinders the access to courts, and therefore should surpass any type of challenges there. So very supportive. The more I get into it, the more I read through, like Senator West, is the more I shake my head. Yes, it's a great idea, and I appreciate it. Thank you.
Thank you, Senator. I appreciate the question. Are there any other questions or comments from any of the members? Senator West has another question. Go right ahead, sir.
Thank you, Mr. Chairman. This is questions for the cabinet. Is this, in your opinion, is this a major change to the existing statutory framework, regulatory framework?
Senator West, thank you for that question. No, it isn't a major change because what we're simply doing is we're replacing the reconsideration process with the medical director. So we're not adding a layer of bureaucracy. We're actually, in fact, Senator Yates had mentioned earlier, not only is it a benefit to employees, but it's a financial benefit to insurance companies. We're taking that responsibility to hold that reconsideration process, which may typically cost an insurance company $1,000 to $1,500, and we're placing it on the medical directors, placing it in his or her responsibility, and the fee is only $200 for the appeal. So there is a net savings of anywhere from $1,200, if I'm math correct, $1,300 to $800 in benefit. So I would not call it a major change. It is a change, obviously, but we're not adding any layers of appeal.
What did we say the fiscal impact would be if this were to be put in place?
Yes, I think you were you're referencing the discussion we had in President Stiver's chambers. We had estimated $400,000, and I think one of the members of the Senate had raised concerns about that issue, and he thought it might be up to close to $1 million to implement.
Yeah. Just to sum up, on this committee, we deal a lot in process. And I think this is one of those issues where we're not talking about what is the best idea in the end. We're talking about changing a statute through regulation. I would totally disagree. I think this is a major change to the current structure and how we go about workers' comp claims. I mean, you're installing a new medical director. The cabinet says $300,000 or $400,000. We probably think it's closer to $1 million. You're setting up a new bureaucracy. They have to have the position. They have to have staff. They have to have offices. Those sorts of things. And the first time this issue came in front of the committee, I think in August, I said this was a major sea change, and all kinds of red flags came up. But you all agreed to defer, and you came back and presented again, and I got a little bit closer as we went along. But when we had our meeting in the Senate with Senate leadership, I thought that was a negotiation, and I thought we were negotiating, and that we would take the next step, and this would just go into session. And apparently that's not the case. And I personally, I think it should go into session. I think this is a major sea change to the workers' comp statute, to the regulation that needs to be changed by statute. I think the legislature needs to weigh in on this, especially those members who are experts in the workers' comp field. I'm not an expert in the workers' comp field, but we do have 138 members. We do have lawyers and those who specialize in workers' comp, and they can chime in on this. As Mr. O'Daniel stated, there are statutory deficiencies. He just said he pointed out there are clearly conflicts between this proposed regulation and existing statute. The Enabling Statute 342-260, yes, that allows the commissioner to speed up the process, but that doesn't allow he or she to do just whatever they choose to do to speed up the process. I mean, we really do need this to be heard in a Senate committee or a House committee, in my opinion. So because of that, I think we've had a full hearing on this, and I think the chairman has a statement or question.
I do have a statement. Before we proceed, I have been actually informed by staff, and there is an agency amendment to this regulation. And before we proceed, the agency amendment, is there any discussion on this agency amendment And I would like to ask exactly, just real quickly, to tell us what that agency amendment is specifically.
In large part, Senator, it was to incorporate the things we were hearing as we discussed this regulation with stakeholders. Certain ones pointed out to us that they would like some more specific information as to what the requirements are for the medical director. Those were incorporated in here. Others pointed out that they felt like the triggering events were a little short. In other words, like the $1,000 limit versus a $3,000 limit. So we raised that to $3,000. The same thing with some cumulative days off, those sorts of things. Those got incorporated. I believe at the beginning they kind of read off most of the changes, but most of those changes came about because we were holding discussions with various stakeholder groups that were noting some things that they felt would be beneficial to the regulation.
Okay, thank you, sir. I appreciate, we appreciate that very much. Is there a motion for approval of this agency amendment? There is a motion. Is there a second?
Second.
There is a second. Without objection, it is so ordered. Is there any other comments from any of the members concerning this regulation or any proposals to be made at this time?
I'd like to make a proposal.
Senator West.
Yes, Mr. Chairman. I would like to ask the cabinet if they would be willing to withdraw this regulation and that we would proceed into session in January, which is a month and a half away, and that we would continue negotiations and continue to work with them on coming together on this.
You may respond.
Apologies. Thank you, Senator. At the present time, the cabinet believes that this is a good regulation. We've worked on it for nigh on 16 months now. We have deferred, as you mentioned, on several occasions, and we obviously appreciate the opportunity to work with you and Co-Chair Hale and the Senate President as well. We believe that this is a regulation that is going to speed up the treatment for injured workers in Kentucky, and we believe that the injured workers in Kentucky can't wait. This is an important regulation. It does make changes, as you referenced, but it does not increase any bureaucracy to the system, and in fact makes it more efficient and reduces costs for all involved. For that reason, we would like to proceed on with this regulation. And again, we understand that you would like to address this in a legislative session, and that is, of course, the prerogative of the General Assembly, and we do believe that the General Assembly has the authority to make such changes.
Thank you. Before we proceed, I'd just like to say I think the consensus of this committee is that we are not opposing what is being proposed here in this regulation. I think all of us would certainly agree that there needs to be something that would make these timeframes quicker for individuals that are filing claims, and certainly the idea of this is not something that I think that we're opposed to, but in discussions that we have had previously with you gentlemen and other folks as well, it seems like the same regulation keeps coming back to us month after month after month. And so I think there is going to be someone has a proposal they'd like to make at this time. Senator West.
Thank you, Mr. Chairman. Before I make my motion, I just want to reiterate that the idea that this regulation does not add bureaucracy is really absurd, because we're hiring a new medical director, we're paying that person, we're providing them with staff, we're adding a section to the regulatory framework that doesn't exist, and we're giving them new duties, and they can make decisions where administrative law judges would make those decisions in the past. So this is clear. This is a completely new bureaucracy. We can argue about the size of that bureaucracy, but it's a major change, I believe. And For the reasons stated previously, I would now make a motion for deficiency under 13A030 2A10.
There has been a motion made today to find this regulation deficient by this subcommittee. Is there a second? Second. There is a motion and a second. Is there any discussion on the motion to find this regulation deficient? All right, there is no discussion. So the question on this motion to find this regulation deficient, we will call the roll. Each member will respond. If they are in favor of finding this regulation deficient, they will vote aye. If they are opposed to finding this regulation deficient, they will vote no. It will take 5 votes of this committee in favor of this motion to find it deficient, and the individuals that are on line with us today, when your name is called, please clearly make your vote as either an aye for a yes to find this deficient or a no not to find this deficient. Please call the roll at this time.
Senator Rocky Adams.
Aye.
Senator Alvarado.
If I can explain my vote, Mr. Chairman.
Yes, sir.
So again, to the gentleman, they're describing all the things that you're wanting in this bill. I don't necessarily disagree with the policy here. Again, this is a medical review panel of 1. All the arguments you're making about this is not going to delay access to the courts are arguments I've made regarding medical review panels in the past. This is going to be better for workers and for patients. Same arguments I've made. The only problem is the Supreme Court disagreed with those arguments. And so although you can say that, and I sympathize with those arguments and I sympathize with the discussion, to have people that are medically inclined have an understanding of this situation to make those decisions, I don't disagree with the policy of this. This has already been argued in other methods and other laws. So I'm going to cast an aye vote today, Mr. Chairman, to find this deficient. And I would welcome the input of the attorneys that are present today to help us achieve a constitutional amendment to give the legislature the authority to make these changes so that our Supreme Court doesn't throw these things out. And I'm welcoming your all's input to get that accomplished in the year ahead. So I cast an aye vote. Thank you.
Thank you, sir. Please continue.
Senator Yates.
No, not to find it deficient.
Representative Bridges.
My vote's aye, find it deficient.
Thank you. Representative Frazier.
Aye.
Representative Marzian.
I vote no for our workers in Kentucky that may have quicker access to health care. I vote no.
Senator West.
Aye.
And Representative Hale.
Aye.
There are 6 yes votes.
The roll call shows that 6 members voting aye and 2 members voting no. The motion to find this regulation deficient has passed. Please proceed with the next regulation at this time.
Public Protection Cabinet, Department of Insurance, 806 KAR 11020 with the staff suggested amendment, and 806 KAR 39070 also with the staff suggested amendment.
806-11020 amends provisions for multiple employer welfare arrangements to update definitions, clarify application procedures, establish a $500 filing fee, clarify information to be submitted, establish recording requirements, penalties, and exemptions, and establish material incorporated by reference. 806-39070 amends motor vehicle insurance requirements to make technical corrections and delete material incorporated by reference. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record today at this time?
Yes, Mr. Chairman. I am Sharon Clark, Commissioner of the Department of Insurance. I also have with me Chad Thompson, who is the department's general counsel. And from the Commissioner's office, I have Sean Orm and Abigail Gall, sir.
All right. Thank you very much. We appreciate your time today. There are staff amendments. Is there a motion for approval of the staff amendment? There is a motion. Was there a second? There was a second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee at this time? Senator West has a question. Go right ahead, Senator.
Thank you, Mr. Chairman. Another job of this committee is to keep an eye on fees, and I see a $500 filing fee, so my red flags went up. Could you explain what that is? Is that, it looks to be you're establishing a $500 filing fee, but explain how that works, please.
Yes, sir. That is a standard fee that is for entities that are registered with the department as opposed to having a certificate of authority. We do that with the pharmacy benefit managers and various other entities, sir.
So it's not really a new fee per se. It's just
no, sir.
Okay.
That's correct. Thank you, Senator.
Thank you.
Any other questions? There appears to be no other questions, so thank you all again for your time. Please call the next regulation at this time.
Thank you.
Thank you.
Thanks, sir.
You're welcome.
Department of Housing, Buildings, and Construction, 815 KAR 4010, 025 with a staff suggested amendment, and 027, 815 KAR 7080 and 110, both with staff suggested amendments, 815 KAR 10060 with a staff suggested amendment, 070, 20050, 195, 30010, and 30060. 060 has a staff suggested amendment.
815-4010 amends annual inspection provisions for elevators and other automated conveyances, including to include guideway system and increase all fees. 815-4025 amends permit and inspection fees for elevators and other automated conveyances to include guideway systems, revised definitions, clarify provisions for freight elevators, establish an elevator inspection checklist, and add material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 815-4027 amends reporting incidents of injury or death related to elevator and other automated conveyances to clarify conditions and make technical corrections. 815-7080 amends requirements for licensing sprinkler contractors to revise definitions and material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 815-7110 amends requirements for local governments to expand jurisdiction for building code plan review, inspection, and enforcement to clarify that agreements between the local government and the department shall be in writing. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 815-10060 amends requirements to protect against fire loss, to revise definitions, delete the requirement for local fire officials to report to the state fire marshal in specific situations, clarify testing and reporting requirements for fire protection systems, and update material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 815-10070 amends requirements for fireworks to make technical corrections. 815-20050 amends provisions for plumbing installation permits to make technical corrections and increase permit fees. 815-195 amends requirements for medical gas piping to make technical corrections and increase fees. 815-30010 amends provisions for working with liquefied gas to establish definitions, reorganize and update requirements for financial responsibility, and clarify application and renewal procedures. 815-30060 amends requirements for underground petroleum storage tank contractors to make technical corrections and revise definitions. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Thank you very much. Good explanation. Would you please identify yourselves today, whoever is joining us at this time?
Mr. Chairman, this is Rick Rand. I'm the Commissioner of the Department of Housing, Building, Construction, and I am with you via telephone.
Thank you, Mr. Commissioner. Anyone else?
Yes, Mr. Chairman, Max Fuller, Deputy Commissioner of the Department of Housing, Buildings, and Construction. I'm joined in the room with Benjamin Siegel, General Counsel, David Moore, Director of the Division of Plumbing, and Mike Haney, State Fire Marshal.
Thank you each one for being with us today. We certainly appreciate your time. There are staff amendments to these regulations, of which there were several that were brought to our attention from the Department of Housing, Building, Construction. Is there a motion for approval of the staff amendments? There is a motion and there is a second. Without objection, it is so ordered. I would just, I don't actually have a question, but I actually, myself and Commissioner Rand spoke on these specific set of regulations, and he shared with me, Commissioner, thank you for your time of doing that, a very detailed information about these regulations. There is certainly, it sounds like there's the one thing that I think jumps out to all of us when we see these regulations is it talks about an increase of fees. But in my conversation with the commissioner, I was certainly appreciative of his response to that and the need for what they need to be doing through these regulations. So I want to just make that on the record. Is there anybody else has any comments or questions? Again, thank you, Commissioner, for your time the other day and all the other folks that's with us today. We appreciate that.
Thank you, Mr. Chair. Thanks to every member on the committee. We appreciate it.
All right. Please go to the next regulation at this time. Thank you.
Cabinet for Health and Family Services, Office of Telehealth Services, 900 KAR 12005 Emergency.
900-12005 Emergency establishes terms and provisions for telehealth, including requirements to protect confidentiality in a technological context, the amended after comments version as a definition for healthcare provider, and clarifies requirements for healthcare providers performing telehealth or digital health services.
Would you please identify yourself today for the record?
Yes, I'm Donna Vino. I'm the Division Director of Telehealth Services for the Cabinet for Health and Family Services.
Ms. Vino, are you the only one today?
I have Kim Minter on the phone, or I'm sorry, on the video as well.
Okay. Ms. Minter, could you identify yourself, please?
Hello. This is Kim Minter. I'm a staff assistant with our office.
Thank you, ma'am, very much. Appreciate that. There are no amendments to the regulations or to this regulation. Are there any questions from any of the members of the subcommittee? We do have a question from Senator Alvarado. Go right ahead, Senator.
Thank you, Mr. Chairman. Can you explain to us why this is an emergency regulation? I mean, when I look at the changes in the wording, it effectively talks about defining what a healthcare provider is, adding to that definition, and establishing guidelines to contact, refer, and obtain treatment for a patient who needs emergency or higher level of care. How is this an emergency?
It was, Senator, it was an emergency because the glossary of telehealth terminologies were to be used by the Department of Insurance health plans, and the health plans for calendar year 2020 had to be in by the end of last month. So it was an emergency regulation because of that.
A definition needed to be put in emergently, and the guidelines to contact, refer, and obtain treatment. That was
yes. The terminology, the telehealth terminology, needed to be included in those health benefit plans, and that was at the request of the Department of Insurance.
Okay, all right. I'd be curious to see those at least, if anybody can forward me that information, would be great to find where that is. I mean, and obviously we do really well when it comes to telehealth. The only thing that concerns with the language here is it establishing guidelines, contact, refer, and obtain treatment for people with emergency or high level of care. That's going to require guidelines to be established at a later time. Is that correct?
Yes, that's correct. The providers will establish those guidelines.
I'd like to have input on that. I know there's, depending on how those guidelines are worded, could add a lot of liability. And if that adds that, you might see a lot less people using telehealth services for fear of adding a lot of that on there. I mean, there's some understood things that are there, but the more specific we get, the more it can impact people not using telehealth services or providing care that way. So I'd like to have some input when that time comes. I would appreciate that opportunity. Thank you. Thank you, Mr. Chairman.
Sure. Thank you, Senator.
Senator West has a question.
Thank you, Mr. Chairman. Reading the summary here we have regarding this reg, it says establishes terms and provisions for telehealth, including requirements to protect confidentiality in a technological context. I'm assuming this means, a doctor, healthcare professional is required already to protect confidential information. This would just apply that to telehealth settings. Is that Is that how that?
That is correct. Whatever the clinician does in an in-person setting, they apply it to a telehealth encounter. And then the compliance with the False Claims Act, the Anti-Kickback Statute, and the Physician Self-Referral are the three laws, federal laws, that the clinicians have to follow to be compliant with.
A follow-up question, Mr. Chairman.
Yes, sir. Please go right ahead.
Does that confidentiality apply to the Department for Public Health? Like, for instance, if there was a patient in a general practitioner's office, they're required to keep that information confidential. So does that apply to the Kentucky Department for Public Health?
It requires to all clinicians and the patient and anybody that would be in the telehealth encounter at that time of the service.
So I hear that as yes.
Yes.
Okay. Thank you.
And when a telehealth consult or a telehealth encounter is done or performed, it requires an informed consent, and you're supposed to identify all individuals in the room where the patient is located as well as where the clinician is. And that does give the patient the ability to say, no, I don't want to go on further with this encounter. But if that patient is okay with who's in the room, then they can go on further with the visit.
Thank you.
Mm-hmm.
Are there any further questions? There appearing to be no further questions. Thank you this afternoon for your time. Please call the next regulation.
Department for Community-Based Services, 922 KAR 2 160. There are no additional amendments.
This regulation amends to increase the reimbursement rate for full-day care by $2 and to require participating providers to complete annual training on billing.
Would you please identify yourself today for the record?
Good afternoon. My name is Laura Began, and I'm the Regulation Coordinator for the Department for Community-Based Services.
Thank you, Ms. Began. Anyone else with you today?
It's just me at the moment. Our Child Care Director, Dr. Sarah Vanover, had to step away for a moment for a scheduling conflict, so I'm not sure she'll make it back in time.
That's perfectly fine. We do appreciate your time today. There are no amendments on this regulation. Are there any questions from any of the members? There appears to be no questions, so we thank you again. And please call the next regulation.
Department of Disability Determination Services, 923 KAR 2 470. This has a staff suggested amendment.
This regulation amends to update agency references and to update state and federal citations. The staff amendment amends various sections to comply with 13A drafting requirements.
Would you please identify yourself today for the record at this time?
Good afternoon, Mr. Chairman. This is Wesley Phelps, Medical Relations Branch Manager for Disability Determinations.
Thank you, Mr. Phelps. Are you the only one?
Good afternoon. My name is John Page, and I'm the Assistant Director of Disability.
Thank you, gentlemen, very much for your time today. There is a staff amendment. Is there a motion for the approval of the staff amendment? There is a motion. Is there a second?
Second.
There has been a second. Without objection, it is so ordered. Are there any questions from any of the members for either of the gentlemen today? There appears to be no questions. We thank you both for your time today.
Thank you.
You are very welcome. I think that brings our meeting to a conclusion today. So I'm going to ask that the next meeting date would be announced at this time.
There are a lot of conflicting schedules. It looks like the least amount of conflict would be December 9th, which is Thursday, would be at 1 p.m.
I know there are several individuals that have specific appointments and specific things that they're going to be at on that day, but we do have to try to get this concluded by the 15th. I'm correct? So the date that we found the least problems with as far as getting our members here would be December the 9th. So we are going to proceed with that. And if there are members that cannot be with us in person, maybe they could join us by video as long as we can have a quorum. They can be either in person or on video. So the next date of the meeting, or the next date for the December meeting, will be December the 9th on a Thursday at 1 p.m. There being no further business, the meeting is adjourned.